With that being said, we have Roe v. Wade being overturned on Friday, and rightfully so. Now, listening to the progressive left in the streets, as well as Democrats, and they're shouting a bunch of nonsense, which is typical, they have no clue on the history of Roe v. Wade, how the opinion got established, where those opinions came from, which was Griswold v. Connecticut, and even Griswold v. Connecticut had their opinions that was pre-established. All these things that I want to talk about here before we get into the craziness of celebrities like The View hosts and all the shenanigans that they're saying. So we're going to do a short synopsis here, and then we're going to roll into the main news. Because I don't want us to be ignorant, just like the left are, shouting a bunch of crazy crap and not having these ideas fully formed and fully fledged. So with Griswold v. Connecticut, short synopsis is you had a executive director, to be specific, of Planned Parenthood, working in conjunction with a doctor to prescribe birth control. And this was not allowed by the state. So as you'd imagine, they got in trouble, they got indicted, got arrested, all this stuff, and it went to the courts. The courts ruled, ended up going to the Supreme Court, and that's where we get Griswold v. Connecticut. Well, the Supreme Court ruled in a 7-2 decision that the law violated the rights to marital privacy. Justice William O. Douglas wrote for the majority and suggested, quote, the specific guarantees in the Bill of Rights have penumbras, and what they call these penumbras are shadows, formed by emanations from these guarantees that help give them life and substance. In layman terms, the Bill of Rights has a source that creates an umbrella effect and establishes the shadows where new rights can be discovered. Notice the source, or in other words, emanations, are unspecified by Douglas. Nowhere in his writings does he actually talk about how he got to that conclusion. He just made it out of whole cloth. And we're going to see that time and time again from Douglas, just creating things out of thin air. According to Douglas, these rights had always been there, unbeknownst to the framers, and eluded elected legislatures for 176 years. Within the shadow, Douglas argued that there was a zone of privacy that emanates from the First Amendment, Third Amendment, Fourth Amendment, Fifth Amendment, Ninth Amendment, and 14th Amendment. So if that kind of went over your head, basically what Douglas did was he said, look, the Bill of Rights casts an umbrella. And from that umbrella, it gives off shadows. And within these shadows, you could find newly discovered rights that had, quote, always been there, but somehow, like I said, eluded the framers and the founders for like 176 years. Nobody had ever seen them before. You can't find them in the Constitution. You can't find abortion. You can't find the right or zone of privacy, but somehow they're there. He argued and would go on to say that the Third Amendment, which deals with the prohibition against quartering of soldiers in any house with consent in peacetime, could be absorbed by the so-called zone of privacy. The Fourth Amendment, which prohibits unreasonable searches and seizures, along with the Fifth Amendment, privilege against self-incrimination, was also attached. Somehow, this, quote, zone of privacy was transformed into the right of privacy by switching words, as you can imagine, from zone to right. 3 other justices utilized the Ninth and 14th Amendments in their concurring opinions with Justice Douglas. The Ninth Amendment states, quote, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Justice Arthur Goldberg used to argue this as that will allow the court to find the right of privacy or the fundamental right of marital privacy without actually having to find the specific constitutional amendment that says so. So again, the right to privacy as well as the fundamental right of marital privacy does not actually have to be specified verbatim in the Constitution for them or such people to have that right. Both justices, John Marshall Harlan II and Byron White, used the 14th Amendment to support the right of privacy is included in the Due Process Clause and has traditionally been protected by American society. If it seems like there was some mental gymnastics going on, that's because there was. Remember, Griswold v. Connecticut was about birth control, and somehow birth control is being attached to the ban against quartering soldiers in private homes. Moreover, what does Connecticut state's birth control have to do with unreasonable search and seizures? According to the court, this can all be found in the shadows of the Bill of Rights. The way the court sees it, the Ninth Amendment grants the freedom to scour these shadows, to find rights that are not listed in the Constitution, and magically attach those newly found rights to pre-established rights. This is not how the law is intended to work. It has paved the way for justices to rule on a policy outcome that they like. Which is funny because they're saying Justice Thomas and others are doing the same thing today, that they're using their religious beliefs to enact certain laws, and that comes from The View, which we'll see in a moment. These cases laid the groundwork for a case that would change our elected democracy forever. On January 22nd, 1973, the Supreme Court issued a 7-2 decision that the United States Constitution protects a woman's right to choose an abortion. Prior to Roe v. Wade, state legislatures decided what laws would govern the practice of abortion. This led to various states throughout the Union having different legislation around abortion. In 1969, a woman named Norma McCorvey was pregnant with her third child. After deciding she no longer wanted to keep the child, she sought a place that would perform an abortion. At the time, Texas law did not allow the practice of abortion. Well, she was adamant about getting one, so McCorvey was referred to Linda Coffey and Sarah Weddington, who were looking to represent women seeking abortions. Her case made it all the way to the Supreme Court, but instead of using the name Norma McCorvey, she used Jane Roe. So that's how you get to that idea of who that was. Henry Wade was the district attorney of Dallas County at the time. The District Court of Texas ruled that the state's abortion law was illegal. The reasoning given him by the state was it violated the constitutional right to privacy. Again, this right to privacy you're going to hear time and time again. Mind you, I'm a big advocate of privacy, but if it's not specified and you're just coming up with things, it needs to be written in there, which you can do. Just put it in there. The Supreme Court struck down the Texas law banning abortion. With this ruling, abortion becomes effectively legal across the nation. Furthermore, the court found that it was up to a woman during the first trimester if she wanted an abortion. During the second trimester, it would be left up to the governments to regulate abortion, but not ban it. This was to allow the protection of the mother that may have health concerns. In the third trimester, if the fetus could survive on its own outside the womb, it should be protected by the state. This was the exception to the mother's health if it was in danger. All of this was a, quote, right to privacy protected by the 14th Amendment. In writing the opinion of the majority, Justice Harry Blackmun performed the same mental gymnastics as Justice Douglas did. During Griswold v. Connecticut, if you remember, Justice Douglas invented new rights from the shadows that emanated from the Bill of Rights. Justice Blackmun, took those invented rights and ruled that the Due Process Clause was included in the right of privacy. The 14th Amendment was not intended to create any new rights, but to secure all persons, notably including freed slaves, that their descendants, the right and liberty guaranteed by the Constitution, which contradicts what they were actually trying to put in place themselves. They construed the 14th Amendment to enact certain rights to privacy or right of privacy because of the Due Process Clause, but that's not what history showed us in terms of what was the creation of the 14th Amendment and what was the purpose of it. The court had created a right so large that itself had penumbras, meaning they basically established the right of privacy and made it so general and so broad that within itself created shadows that you could find newly found rights within that. The enlargement could encompass almost anything and everything that is performed outside the public view. It has the potential to include child abuse, possession of pornography, or using illicit drugs. The other issue is the court does not have the power to create, and this was one of the main problems with it. The Supreme Court exceeded its constitutional authority by establishing and creating law. Congress has the power to make law, not the judiciary. During Roe, the court literally acted as a legislature by creating the trimester framework in which states would have to abide. As seen through the history of abortion, humanity has been performing abortions for thousands of years. It was not as if the founders and framers were not cognizant of abortion. If they were, a zone of privacy or a right to privacy or a right to abortion, the framers would have included those in the Constitution. If this is a right that American society would like, we would elect politicians to pass an amendment in Congress that grants certain rights. The actions of the court negated our constitutional system for Roe. Under our system, most policy issues have been left up to elected officials. This puts the power in the hands of the people, not the government. In Roe v. Wade, the court decided it was no longer the people who had the authority. Anyone could scour the Constitution to find any sort of reference, right to an abortion, but will not find such right, let alone any word of abortion. The Roe decision has led many legal scholars, justices, and lawyers to create and criticize the decision. I mean, a vast swath of those that believe in the constitutional lawyers. Heck, even Blackmun's own clerk thought that he was wrong, okay? So all these people have come out and said, look, it's just bad law. You could try to make an argument for it, but in terms of how they came to their opinions of construing and finding these within these shadows new rights that were never there in the first place, and again, somehow eluded over 176 years of legals, lawyers, the framers, the founders, is just mind-blowing. So that's how they got to the conclusion of Roe v. Wade, that you have all these rights that somehow just already pre-existed. And that's why ultimately it was overturned, because it was bad law. It created bad precedents. And that's what they're saying now, the left, going, oh, well, it already had been in the past there, so we should just go along with it. If anybody knows the Constitution, there's a lot of things that were put in place in the Constitution that were ultimately upended because they were dumb and stupid and shouldn't have been placed in the first half of our history at least. But that's stuff that they're not going to touch. So that was a brief history of what took place with Roe v. Wade. I encourage all of you to even go further in detail and see how Griswold v. Connecticut came to their decision, because what Douglas did was he took prior cases, multiple cases, and kind of entwined them all together to come to his conclusions. And then in Roe v. Wade, they took those entwinements, attached them basically in a nice lump sum to find these zone of rights or rights to privacy per marital rights, and then establish a more broader right from that for Roe v. Wade that just created bad law for everybody. And again, you had the Supreme Court acting as a legislature, which is not their job. I hope you enjoyed that clip from the Bald Brad Show. If you did, make sure to hit that subscribe button so you can stay up to date on all our future content.